The matter for Lordship.
What is the matter about?
Matter about essential service, stoppage of essential service in medical college, Lordship. Last date is 31st, Lordship. Cleaning and other essential service, Lordship.
Stoppage.
Sorry.
Stoppage of?
Essential services, Lordship, in medical colleges.
New case.
Yes, Lordship.
Okay.
May it please your lordship. My lord, my writ petition, new writ petition would become infractuous by the close of tomorrow. I have a bonded warehouse, my lord, liquor, and I had applied within the statutory period for renewal. The excise rules holding the field require the deputy commissioner, the collector, as it's worded therein, to give a nod to it, yes or no. If for my reasons attributable or otherwise, I cross 31st of March, license gone. So I filed in February mid, which was a salary period. Since nothing was forthcoming, 29th, I even submitted a representation. So unless I have a protective order of the court, everything is gone. Although for no attributable fault of mine, I may pray at 2, but I would pray tomorrow, the same thing tomorrow, with a liberty to take it as the first item. Otherwise, tomorrow, I'm not bothering today, tomorrow as the first item. That is the case. Or at 2 o'clock, if lordship pleases.
We can do it at 2, we'll try. But I have got a meeting at lunch, so I might take a little time during lunch.
In that context,
We can try.
tomorrow at 2 we'll try.
Anything, we can try that after 2, exactly 2, I will not be here.
Very well. I'm obliged.
Two.
Grateful.
You make sure that the excise person is here.
Yes, sir.
May I please, your lordship? I beg to mention this daily item number 9.
9.
I am appearing on behalf of KK Parakor, correspondent number 1 and 2. He is out of Guwahati due to some personal dispute.
You are appearing on behalf of Mr.
KK Parakor.
His name is not here.
Respondent.
Or respondent.
Yes. Due to
KK
some personal
Parashar.
dispute,
Okay.
He is out of Guwahati.
Okay, have you spoken to the petitioner?
Yes, lordship.
They have agreed.
They have agreed.
Mr. Your
K.
name?
Kalita.
A. Kalita.
K. Kalita.
K. Kalita. Prays for adjournment on behalf of Mr. KK Parashar CGC. Full stop. He submits that he has also taken the consent of the petitioner's counsel. Full stop. In view of the above, the matter is adjourned for
2 weeks.
2 weeks.
Of like
May it please, my lord, this content petition may be listed tomorrow for withdrawal, my lord.
May I please? With the consent of the respondent, I beg to mention item number 4.
4.
Yes, senior counsel, Mr. Kiddemonde is in bereavement.
Bereavement.
Yes. Due to demise of his father.
When did his father expire?
Lordship,
When did his father expire?
on 28th of March. Yes, sir. I pray for 10 days. Item number 4.
Okay, right. Adjournment prayer has been made on behalf of Mr. T.J. Mahanta, whose father expired on
28th.
2003,
Yes.
2020. Accordingly, list this matter. List this matter on 12th. 12th?
Yes.
Not 12th, make it 11th.
Obliging.
May it please your lordship. I beg to mention item number 11 of today's date.
11th.
I've taken
Yes.
the consent of the other side and I have already submitted the adjournment slip. Your lordship, let the matter be listed after the Bihu vacations.
Okay, right. On the prayer for adjournment made by Mr. S. Datta, counsel for the
Petition.
petitioner, who submits that he has taken the consent of the other side. This is the matter after the Bihu vacation.
Lordship, I would like to mention item number 10.
Yeah.
With the consent of the other party, my senior grade won't be able to come, so let the matter be listed after vacation.
On the prayer for adjournment, how many times has it been adjourned, madam?
Lordship.
How many times has it been adjourned?
No, Lordship, last, they have not filed affidavit till now.
They have not filed affidavit.
No, Lordship.
Who is for the other side?
Lordship B. Ahmed.
B. Ahmed, though, I had never seen him. Is he all right? Huh? He's ill since long time back. taxes, taxation. What has happened to Dr. Ahmed?
Long time I did not see him.
Now cases, he's just adjourning one after the other, that's 2018. Yeah,
I'm told he is having serious diabetic
correct.
issues.
Now, who have you spoken to? Which council have you spoken to?
Lordship, my senior councillors said they have spoken to the other respondents.
Who is the other respondent?
He's junior. He's junior.
Okay, right. On the prayer for adjournment made on behalf of Dr. BP Toti. List the matter on twenty 2004.
Highly obliged.
May I please, your lordship? I beg to mention item number 12
Yes,
for adjournment. My lord.
on the prayer for adjournment made on behalf of Mr. M.U. Mahmood. This is the matter after the beautification.
Obliged, your lord.
May I please, your lordship, I beg to mention item number 7 and 8.
Yes,
Yes, lordship, can it be taken up?
entry tax.
Yes, lordship. Can it be? Today's.
Huh?
Today, lordship, I've got some difficulty. But,
Your father?
I'm for the finance and taxation department.
Okay, Mr. B. Chaudhary. Learned counsel for the finance and taxation department. Place for adjournment on stating that he has got some personal difficulty today. Who is for the petitioner?
I was serious.
Miss
Jane, on behalf of N. Havelia.
Miss S. Jane. On
Jane,
behalf of
on-
Miss N. Havelia submits that she has got no objection to the settlement. Accordingly, leave this matter,
Lordship immediately after beautification.
leave this matter after the beautification.
Obliged.
May I please, your lordship? I'm praying for listing. Praying for listing, lordship. The matter.
New matter. What is the matter about?
Matter, lordship, non-payment of contractual bill, lordship.
What is the hurry? It will come, non-payment of. Your contract you completed it which year?
Completed, lordship.
When?
50%,
When did you complete?
2012, lordship.
2012?
Yes.
And you suddenly wanted,
20.
when did you file this writ petition?
50% have already paid, lordship.
When did you file the writ petition?
2022, lordship.
2022, after 10 years, and you are in a hurry now. You wait, it will come in time.
My lord. Item number 2,
Item 2, yes.
my lord, the petitioner number 2 died. So I may be allowed to file a substitution petition. my lord.
Yes, we are allowed, we'll see. Yes. Yes, what is this, the contractual dues?
My lord. My lord, it's a long pending case, my lord.
Correct.
Dues of 2007, filed in 2020, my lord.
Ah.
I have to take up to the instruction regarding.
You take instructions, why haven't you, it's been pending here for nearly 3 years now.
Yes, my lord. They listed after a long time, my lord. I'll take care of them.
Okay, right. Mr. D.R. Gogoi, learned counsel for the petitioner, submits that the petition number 2 has expired.
Right.
And he would accordingly like to file an application for substitution of the respondent number 2, petition number 2. Full stop. On the other hand, Mr.
As doctor for 1 and 3.
S. Dutta for the respondents number 1 and 3 submits that he needs time to, submits that he has not received instructions as to why the contractual dues payable to the contractual dues claimed by the petitioner has not been paid to the petitioners.
And she's appearing for, my colleague is appearing for respondent 2.
Miss,
AB Kayastha.
Huh?
AB Kayastha for election commission.
A. B. Kayastha.
you got appears for respondent number 2. List the matter after the beautification. When do you want it, Mr. Gogoi?
My lord, anytime, my lord. I am not in a hurry.
You're not in a hurry.
Because my lord, main person died, my lord. Main person died.
Main person died.
Wife was to come as a substitute applicant.
Okay, list the matter after the beautification.
Substitution is allowed?
Highly obliged.
Huh?
Substitution is allowed?
I mean, we don't know who to substitute. Who do we substitute?
Well, as one petition number 2. They have
Huh?
to file an application
Petitioner number 2 is to be substituted by whom?
by his wife.
What is the name of the wife?
They have to file application, my lord.
Please. Give the minimum requirements at least. Substitution allowed. How can we just allow? We don't know if she has an existing wife, living wife, whether he's a bachelor. We don't know. You file an application.
My lord. Apply. I'll apply.
Madam, this is a matter for listing, admission matter, my lord. Any date next week, madam.
What's the hurry? No hurry.
Harry, my lord, my cow were seized, my lord, but that
Your
was cows, my lord.
cows were seized.
Seized, my lord. That was, I got acquittal, my lord. Court orders to hand over the cows, but did not given still now. My lord. Report was called for by this honorable court, but till date, my lord, it is not listed yet.
In a writ petition,
Great petition tribunal.
court has directed that the cow should be handed over to you.
Court and directed to submit report by the police.
Submit report by the police. It's a criminal writ petition or what?
It's criminal report.
Criminal.
Any date, my lord, next week.
Next week, we are very.
The cows are, my lord, in.
They're getting fed. You don't have to worry about their food.
Not getting paid, my lord.
Huh?
I am the owner, my lord, but still they are not handed over.
They must be in some Gaushala or something.
It is in Gaushala, my lord,
Then
but they are not giving proper
proper food.
fruits or anything.
You go give vitamin C or something. You go separately. Anyway, right. Okay, right. You give a date when. Huh? Okay.
Apply.
May I please, your lordship.
Mr.
Please, enough.
P. Singha, learned counsel for the petitioner, says that he would like to withdraw the writ petition. Mr. B. K. Das appears
1, 2, and 3.
appears for point number 1, 2, and 3. The pair of the petitions counsel is allowed. The writ petition is dismissed as withdrawn.
My
Obliged.
interim order stands. Lord, bracket.
Interim order stands vacated.
Your lordship, my learned friend was supposed to get the instruction.
Yes.
Demand notice have been prepared, it will be handed over to me within an hour, my lord.
Demand notice be prepared.
My lord, let it come at 2 PM, my lord, I will hand over the.
No, that is another aspect, actually. Now that is with regard to payment.
Payment, penalty and everything. calculation,
Ah,
sir.
Payment. Now, you open up this, go down.
If the
Huh?
payment is made, it will immediately open up, madam. We are desealing that entire 3 downs. Let me hand over that particular demand notice, madam. Because I don't know. Check.
Okay, as soon as you hand over, then you deseal it.
Not see it, they will pay it and deseal it. We are ready.
No, they will pay, but they'll want to make a reply to it also.
Not see, will fix it at 2 PM, my lord. Let me hand over, let me get over that particular.
Okay, let us get to.
May it please your lordship.
Yes, what is your case, madam?
My lord, the petitioner before your lordship, petitioner number 2 is a catering contractor. He is running his tea stalls at Guwahati and Kamakya railway station. Now, my lord, in pursuance of the tender notice at dated 17/6/2014. My lord, at page 86, the petitioner had responded to it. And he has been selected for it. The tender notice is at Annexure D, page 85, it starts, and concise tender notice number C15/2014. These are for sealed bids were invited for general minor units of A1, A and B category stations over Lamding division. My lord, the petitioner's tea stall, that's Guwahati railway station, belongs to the A1 category, and
Kamakya?
Kamakya is at A category. My lord, thereafter, the Honorable Supreme Court, before the Honorable Supreme Court, the SC caterers case was conducted. And indeed, my lord, the operation,
SC caterer?
yes, my lord. There the,
What do you mean SC caterer?
the case, name of the case, my lord,
Page
page 23.
23.
Yes, my lord, it starts Senior Divisional Commercial Manager versus SCR Caterers.
Okay,
right?
SCR caterer.
Yes, my lord. This is the judgment by Division Bench of the Honorable Supreme Court of Gopala Gaura and our Justice.
What does it
Honorable
say?
Amitabh Roy. My lord, at para 27, therefore, we have to hold that the provisions of the catering policy 2010 are applicable to the concerned respondent. The action of the railways in not granting renewal to the licenses to the members of the respondents is arbitrary, unreasonable, unfair, and discriminatory. My lord, thereafter, this catering, this is
Where are you reading? Page?
page 56, my lord. Para 27. Therefore, we have to hold that the provisions of the catering policy 2010 are applicable to the concerned respondents. Action of the railways in not granting renewal of licenses to the members of the respondent is arbitrary, unreasonable, unfair, and discriminatory. So, my lord, it was settled that the policy that would apply is the catering policy of 2010. That catering policy, your lordship will find at page 61. We are concerned with the tenure, and that is at page 74, lordship, para 16. And
Page 74.
74, para 16.1.3. We are a general minor unit, lordship, and allotment of all general minor units at A, B, and C category station shall be awarded for a period of 5 years with a provision for renewal after every 3 years on.
Where are you reading?
My lord, page 74, para 16.1.3.
16.1.3. Okay.
Yes, my lord. Allotment of all general minor units at A, B, and C category stations shall be awarded for a period of 5 years with a provision for renewal after every 3 years on satisfactory performance. So, my lord, it was clear that the period is 5+3.
Ah.
My lord, thereafter.
On satisfactory performance.
Yes, my lord. So, my lord, thereafter, this catering policy of 2017 was enforced, and your lordship will find that catering policy of 2017. In that, there is a clause at page 177, if I may take your lordship to.
177.
Yes, my lord. Para 20, applicability of the new policy. Para 20.2, the last para, tenderers that have been finalized and LOA issued prior to the date of notification of this policy.
No, this is with this page 177 is with regard to what? Catering policy of 2017.
Yes, my lord.
So they have called for a new tender. They have issued a new tender
Policy has
as per the
now-
policy.
Policy has now changed.
Correct.
So, my lord, that policy, when will it apply? This para 20
Okay.
deals with that.
Ah.
Tenders that have been finalized and LOA issued prior to the date of notification of this policy
Shall be allowed to continue.
as per policy guidelines prevailing at that time.
Ah.
And my lord, then thereafter, the railway board has also been.
Okay, so madam, one thing. According to you,
Yes, my lord.
5+3, 8 years. When did you start your catering business?
My lord, in 2014,
2014, so 5+3, 8 ends in 22.
22, thereafter satisfactory performance, every 3 years they are renewed.
No, let us go back to page 56.
My lord. We
Is it
hold that
56?
the 56 is the
No,
SCR caterer.
74, no?
Yes, my lord.
70.
For renewal after every 3 years. Not just 8 years, but every 3 years there is a renewal that is given. 16.1.3.
After every 3 years.
Yes, my lord, and thereafter, this railway board and different zones has also been renewing the tender and.
So what is
Finally,
your
my
now?
lord-
So what is your grievance now?
My lord, we come to the judgment of this honorable court passed in a similarly situated caterer's case. My lord, if I can.
No. What is it on the facts?
Yeah.
Now you have applied for renewal of your license?
Yes, my lord.
And what has
Now-
happened?
Now this
Has
impugned
it
order
been
has
rejected?
come.
Yes, where is the impugned order?
My lord, at page 22,
Impugned order dated
dated 2/3/23.
2/3/20.
I have been directed to vacate the stalls, which has with expired license. They are interpreting the same as.
Okay.
So my lord, thereafter on, one Rajendra Kumar Mangla
Ah.
approached this honorable court.
Yes.
And our high court was pleased to pass the interim status quo order
Yes,
on 27/3/23. So
Yes.
same order as that, my lord.
Lordship, if she is relying upon a decision of a coordinate bench. Firstly, Lordship, the Supreme Court judgment was not in respect of the policy of 2007. 2017. I'm sorry, 2017. 2017 policy says no renewal tender.
the 2017 is no renewal. Let
No.
us see that.
It has to be settled by way of a tender.
Where is that 2017 policy?
Just now,
Page 162.
yes, Lordship.
Page
Now,
162 and she has relied upon 20.2.
20.2. Now, Lordship will kindly note 20.2, this policy comes into effect from 2017.
Yes. It only says that tenders that have been
At that
finalized
point of time.
prior
At
to
that
the
point of
date
time.
shall be allowed to continue as per policy guidelines prevailing at that time.
At that point of time.
Rural will cancel all such tenders returned the others by case where error has not been issued before issuance.
Now,
Now, where is this here?
it is not a case that her tender was pending at that point of time. She now comes up in 2023, whereas the policy came into effect in 2017.
Ah.
This policy.
Yes.
Now, the policy of 2017 is in effect.
Yes.
So the condition 20.2 will be applicable only where those were not finalized in 2017.
No, that have been
To the
finalized.
date of issue of notification. Prior to the date of issue of notification. Now, if my learned friend is insisting on a decision of a coordinate bench, that status quo, I also have a decision of a coordinate bench which has turned down. Which has turned down.
No, you just show me one thing.
Yes, Lordship.
This 2017 catering policy,
Lordship.
where does it say that there shall be no renewal?
I'll take it. Lordship will give me a time.
Yes, let's take the judgment, let's take the order. Just please give me that order, Mr. Chaudhary, that order.
Or
That's
this,
fine.
yes. Here,
No, you see, as per the 2010 policy,
yes, Lordship.
the renewal could be given
Yes, Lordship.
provided satisfactory performance was.
Yes, Lordship.
Now, what is the major difference between the 2017 policy and the 2010 policy?
2010 Lordship, it was that somebody has got it, it goes on getting renewed.
Record.
Now to give competition, to give better amenities, Lordship, that system of renewal is gone. Now fresh tenders.
Okay, now where is that? Only that.
Lordship, if I may take your lordship to page 170,
Page 17, yes.
170. Nine point three point two,
9.3.2, yes.
will be by open tendering system.
Yes.
9.3.1. Open tendering system.
And what will be the term?
Tenure, my lord, is at page 173. Para 11. Is the tenure of all, 11.1 is tenure of all major units. Then 11.2 is the tenure of all food plazas. We are then, however, concerned with the tenure of a minor unit. General minor unit.
Where is that?
Static.
190, right?
Huh? Where do you get that?
What? Take it. Where is 190?
Acha, 11.2. Tenure of food plaza shall be for a period of 9 years. The tenure of all other catering units, major units and minor units will be for a period of 5 years only. There will be no further extension renewal except for units specifically referred to in para 3.8.1.
$199.
Three point 8.9.
Yeah, both are, Indian plan.
So you are covered by 11.2.
My lord will also come to page 183, where I have annexed the judgment of the Supreme Court in a 32 writ petition. That's Vendors Cooperative Society Limited versus Union of India. My lord, this case has explained the SC caterers judgment.
This has been decided when?
My lord, in 2018. Give your lordship.
Has it dealt with 2017 catering policy?
October 30, 2018.
It was
Which
not.
page do you want me to go to? Most of the pages are just the parties' names only.
Page 186, lordship, we accordingly direct that the aforesaid association of persons, namely the Cooperative Society Partnership Firm and Hindu Undivided Family, it is, in respect of the units covered by the judgment in Senior Divisional Commercial Manager versus Central Railways, shall be entitled to renewal of all licenses they hold as on the date of expiry of this licenses.
This is not a case where lordship has taken this.
No,
has
you
taken
see,
care of
they are referring to the judgment of the earlier case.
Yes, my lord, they have.
And that
explained it.
earlier case was decided prior to the 2017 policy coming into force.
Yes, my lord.
Now, so they were dealing with the 2010 policy.
Yes, my lord.
And the 2010 policy
Provides for renewal.
provides for renewal, but it also speaks of some organizations having more than one catering business.
Yes, my lord.
So it was in that context that a clarification had been made
Yes,
with regard to the 2010 policy.
yes. my
Now we are in the 2017
17
policy.
and
Now 2017 policy says that you are not allowed any extension.
yes, my lord.
Then
Then, my lord, this vendors cooperative is dated subsequent this judgment.
maybe, but then is this,
And then, my lord,
just a minute.
yes, my lord.
this vendors cooperative society
Yes, my lord. It has explained.
order at page 183
Yes, my lord.
is an explanation of the earlier judgment,
Yes, my lord.
which had been made prior to the coming into force of the 2017
No, my lord,
policy.
this was 2018 policy.
Huh?
After
2018
in-
policy?
No, my lord, in 2018, this judgment has come.
Maybe
So,
maybe
before
it had come in 2023 also,
Yes,
maybe.
my lord.
But it was referring to a
The-
judgment that had been made prior to 2017
Yes, my
policy.
lord, in
It-
2000, sometime in 2014, that judgment had come, which in SC caterers. But my lord, the Honorable Supreme Court vendors caterer has explained that, and also, my
No.
lord, again, the railway board has granting extension. Also, the coordinate bench has granted, which judgment my learned senior friend is referring to does not deal with all this. It was in fact,
Lordship, please
if I
kindly
may respectfully submit, my lord, there before the honorable single judge of this honorable court, there were the SC caterer
Lordship,
judgment was not
kindly see-
placed, and so, my lord, it was in a way of judgment rendered par incurium. And my lord,
These are not judgment. These are not, these are
Uh,
judgments or what? These are orders.
SC caterers judgment. Yes,
Mm.
my lord.
Yes, Mr.
Lordship will kindly see the last paragraph of the second page of the judgment.
Yes. Yes,
Taking into consideration that the said aspect of the matter to the effect that the present policy decision of the railways do not have a scheme for renewal. The writ which has been sought for the effect that the members of the petitioners association should not be evicted in the garb of order dated so and so cannot be passed as a right to vend accrues upon the members of the petitioner association on the basis of the prevalent catering policy, and the present catering policy of 2017 does not have the concept of renewal of license. Under such circumstances, this court cannot allow a writ to allow the members of the petitioner association to continue their business of vending, which would be contrary to the policy of 2017.
And my lord, this judgment has been.
Madam,
interfered
just show me in the 2017 catering policy, where is the provision for extension of the license or renewal of license?
But my lord, two thousand
Yes,
seventeen.
madam,
Yes, my,
no, but
yes, my lord.
I'm just asking you a question. If you know the answer, you can answer it, yes or no. If you don't know the answer, there's no question of but. I'm not arguing with you. I'm just asking a question.
Yes, my
If you
lord.
know it, please answer it. Is it there in
There
the
is no
2000?
provision for renewal in the
There is
two
no
thousand
provision for
seventeen policy, but it is clear that it will, those which were granted prior in point of time, they will be guided by the 2010 policy.
Correct, they will continue.
Yes,
But
my lord.
once the term is ended, then there's no question of renewal.
There is no renewal. as
There's
of
no
date.
renewal.
Where do
They
not have
will-
a renewal?
Once they were granted as per the old policy, they will continue to have their term of 5 years, whatever. But subsequent to that, there's no more policy.
My lord will give me some time. I'll place the division bench judgment of this court. There maybe as far as my knowledge
Yes,
goes,
yes,
that
yeah,
order
we'll give you time, no problem.
that order has been interfered to some extent.
Maybe
that-
please show us.
After some
Why
time,
didn't you bring it?
after some time, lord.
Yes, just a minute, we'll write a little bit. Heard Miss B. Chowdhury,
Yes, my lord.
learned counsel for the petitioner, who submits that the communication dated 2/3/2023 issued by the respondent number 5. Where is this 2/3/2023 page?
My lord,
Page 22, Lordship.
Requesting the petitioners to vacate their Food and catering stalls, it should be what is it called? Food and catering stalls?
Catering stall, my.
Ah, catering stall. To vacate the catering stalls. On the ground of their license having expired. Should be set aside. The learned council relies upon clause 16.1.3 of the catering policy 2010. Comma, the where is the judgment you are relying upon?
My lord, SC caterer,
Yes. Page,
56 is the operative part.
SC caterers is, it starts at page 23, Lord.
It starts at page 23.
23. Uh, pa-
And she is relying on paragraph 27 that your lordship will.
Para 27,
27 that your lordship. will
para
find that
27 of the
which
uh,
is-
of the judgment passed by the apex court in civil appeal numbers 618-620 of 2016, inverted commas, senior divisional commercial manager and others versus SCR caterers, comma, dry fruits, comma, fruit juice stalls, welfare association and another, page 23, huh? And what is the other judgment, other order that you relied upon?
Vendors cooperative.
Where
law.
is that page?
Lordship, that starts at page 183.
I'm relying on page 186. Lord. It starts at 183.
And the order dated 30-10-2018 passed in Vendors Cooperative Society Limited and others versus Union of India and others, WPC number 373 of 2017. In support of our submission that the respondents have to the renewal of the petitioner's catering stall license would have to be done unless the respondents can show that unless the respondents can show that the performance of the petitioner in running the catering stalls has not been satisfactory. That is your case. Correct.
My lord,
I think that is her case. Anyway, full stop. Next para. Mr. R.K.D. Chaudhary, the learned deputy SGI, on the other hand, submits that the judgments and orders of the apex court referred to by the counsel for the petitioner pertains to the catering policy of 2010, wherein a provision wherein there was a provision for renewal of the catering stall licenses. Being run in A1 and A category railway station. However, no. However, the said provision for renewal of licenses has been done away with in the catering policy of 2017. Is that correct?
Yes, yes.
2017.
Superseded by 2017.
It is 2017, which has superseded the earlier catering policy of 2010. In this regard, he has relied upon clause
Plus
20.
11.2. 11.2 of the catering policy 2017. He also submits that where is that, the earlier,
Lordship is referring to tendering,
huh?
the provision for tendering.
The provision for, if they were selected as per the old policy and they'll be allowed to continue, where is that?
20.2, Lordship.
20.2, no?
Page
And he also
177.
submits that in terms of clause 20.2 of the catering policy of 2017, tenders that have been finalized and LOA issued prior to the date of the
Notification.
2017 policy, catering policy, would be allowed to continue as per the policy guidelines prevailing at that time. So, however, once the period of 5 years expires, no further renewal of the license can be given in terms of the 2017, in terms of the catering policy of 2017. Here, in support of his submission, the learned Deputy SDI has relied upon the order dated 24/1/2023, passed in WPC 5143/2004. So you're going to get the DB order.
Yes, my lord.
We will wait for you. Let her get today or
Today.
some other day.
Tomorrow then.
Any day you
My
want.
lord, tomorrow.
What she would bring, I was there.
Ah,
The honorable court has not interfered so far as the policy is concerned.
Ah.
What the honorable court has said, if they are still running after expiry, they will be deemed to be the vendors till now.
Okay.
And they have to pay the fees for that. And thereafter, the matter is left to the railways. to
out
decide.
here, I don't find any case, actually. You bring it today. We'll dispose of the entire matter. There's nothing here.
My lord, entire India renewal is granted by
That's why
the
you can go to division bench.
railway board has also granted.
That's why we are giving you, that's why,
I do not wish to
no, entire India might be doing it, but unfortunately, you've got the wrong judge in front of you.
my lord.
Because what I understand from what is being projected in the writ petition, 2017 policy has not been, does not provide for renewal. And 2017 policy is not under challenge. It's not under challenge.
I'll come back, lord.
You come back, but when? 2 o'clock, when?
Tomorrow, if your lordship,
No, tomorrow is too heavy.
then today.
Today at 2. You come back at. Let her come back.
No, please, your lordship. The petitioner is a partner.
Huh?
The petitioner is a partner of a partnership firm.
Is a partnership firm.
Partnership firm
Yes.
along with other partners.
Yeah.
For smooth running of our, it relates to the
Huh?
diagnostic center.
Okay, okay.
healthcare.
Yes.
So for smooth running of our partnership firm, we took loan from SBI, a term loan. Lordship, that loan sanction order is at page 48, annexure 8, dated 22/12/22.
Who is appearing for the other side?
Lordship, they have the panel advocates only.
Call them. Can you call them?
Yesterday I speak with their, but as per their procedure, after issuing notice, bank provide engage them.
No, I'm planning to dispose of this writ petition now itself. Call them. Ye-
Lordship,
Your prayer is that you want 3 months' time. We'll
No.
give you 3 months' time. Call them.
But they should not rescue our machines only on for that.
Huh?
They are intending to recover or seize our machines, Lordship. That's the hardship, Lordship.
You see, you asked for in your writ petition, you have asked for 3 months' time.
Yes, Lordship.
This court will give you 3 months' time.
Lordship,
That's all.
Lordship,
You call one of them.
Lordship. After something.
You call one of them. Yes. So there's the order.
Yes, my lord.
I think,
Pending lordship, in fact,
24/3/22, 23.
so I think,
Malik Chaudhary,
we'll,
finding as at page
that
39.
quarterly
Yes,
and
my lord.
the yearly fee.
Your lordship had also passed.
I had
the
passed an order, I know, long time back.
Yes, yes, sir.
Okay.
So my lord will run similar order as that and fix it for a particular date on
Fix it
2nd
on
of,
the, fix it on the same day.
2nd of May.
lordship will fix it with the other.
Yes, that's what I'm thinking. It is the 2nd of May.
2nd of May.
Heard Miss B. Chowdhury, learned counsel for the petitioners.
Your lordship, I appear for 1, 2.
Ah.
And
Just a minute, just a minute.
Seven.
Okay.
Page 39 is the operative part.
So you want to pay quarterly,
Yes,
correct?
my lord.
Heard Miss Console and counsel for the petition to submit. That the letter dated
3/2/23.
3/2/23. Requiring the petitioners to deposit the license fee on yearly basis. Should be set aside. As. Now, it should be set as they have been paying their license fee on quarterly basis. Correct.
Yes, my lord.
In terms of. In terms of
2/11/22, lordship. At page 30.
2/11/20, in terms of the earlier letter dated 2/11/22. Issued by the
It was issued by the general manager, mobile catering. service.
respondent number.
Respondent number
4.
4, lord.
Respondent number 4. Issue notice returnable on 2/5/2023. Mr. R.K.D. Chaudhary, the deputy SGI. Accepts notice on behalf of respondents number
1, 2, and 7, lordship.
1, 2, and 7.
IRCP is represented by senior advocate Mr. Sayawala.
So who will accept notice?
Lordship, for the time being, lordship, I will do that first.
You do that. Okay, so you make him for three also, huh? 1, 2. Then what of,
All the respondents. list.
huh? All the respondents. Okay, all the respondents. All the respondents. Good stuff. On considering the submissions made by the causes for the parties and considering the order dated 24/3/2023 passed in WPC 1171/2023. It is directed that in the interim, the respondent number 3 shall not insist on deposit of license fee on yearly basis insofar as the petitioners are concerned, and shall receive such license fee on quarterly basis. Till the next returnable date. This is the matter on 2/5.
Grateful.
But what happened in this case, the state of Assam and put a tender for supply of vehicles.
Supply of,
Hence today by today
Huh?
ambulance,
okay,
the animal husbandry. So there are only 3 tenderers.
supply of mobile veterinary unit vehicles. Okay,
Against that, my lord, it was given to the respondent and challenging that the order, we came to the High Court.
Respondent number given to whom?
Naam to kya?
Huh?
Respondent number 6,
So the supply order has been given to the respondent number 6.
yes. We have challenged that and we got a stay.
You challenge that and you got a stay.
That order, I would like to place before your lordship, then we will come to the.
Huh?
Your lordship would kindly come to page 89.
Yes.
Art so and so, so and so. The instant writ petition has been filed in context of an e-tender notice dated 16/12/22, whereby 181 numbers of mobile veterinary unit vehicles would put into operation for execution of a scheme by the state of Assam. The petitioner alleges that the disqualification on the technical ground is on extraneous consideration and the relevant facts have not been taken into consideration. By drawing the attention of this court to the impugned minutes of the meeting dated so and so, the learned senior counsel has submitted that the discussion made by the petitioner would reveal that its disqualification is not accordance with the clauses
Clauses of
of
the
the
tender
tender document. On the other hand, so and so learned counsel, animal husbandry, veterinary department has submitted that the decision does not suffer from any infirmity. The learned standing counsel has drawn the attention of the court to the relevant clauses of the tender document, including 3.2 section 1, as well as clause 4 and so on. Clause 3.2 requires the bidder to submit undertaking that he was not blacklisted and no case was registered against him or his firm. And clause 417 requires the information to be given regarding litigation in the last 3 years in which the bidder is involved. The aforesaid amendment has however been clarified by the learned senior counsel for the petitioner by submitting that there has been an amendment to clause 3.2 in the terms of the disqualification would be on account of the blacklisting and for conviction of an offense under Prevention of 1988 or the Indian Penal Code or any other law for the time being in force at the time of the submission of the. In other words, the learned senior counsel submits that it has been clarified that mere pendency of litigation shall not be a disqualification. A perusal of the impugned minutes of the meeting would, however, prima facie show that the disqualification is not strictly in accordance with the relevant clauses as mentioned above. Issue notice, returnable so and so. Ms. Kotoki and Central Council, Veterinary Department accepts notice on behalf of the respondent 1, 2, 3, 4, and 5. Extra copies to be served upon Kotoki, Learned Senior Council. Steps to service notice upon the respondent number 6 be taken by registered court. Steps within 2 weeks. Heard the Learned Council for the interim prayer. The court is of the prima facie view that the qualification of the petitioner on the technical ground not being strictly in accordance with law. It is directed no further process be undertaken with regard to the tender in question, which has been initiated by e-tender notice dated so and so till the returnable dates.
Yes,
Then we learned, even after hearing the other side, the stay order was granted. But unfortunately, my lord, this was not cared to, and the impugned order was passed at page 91.
Next week.
91, your lordship got
great.
Annexure E. Letter of award for organization of 181 numbers of mobile veterinary unit, vehicles and establishment, so and so. Call center under centrally sponsored scheme under livestock health and disease control program. With reference to the deed, so and so, I dated 18/12/2020 for selection of service provider for organization of optionalization of 181 numbers of mobile veterinary unit, vehicles and establishment of MVU call center under centrally sponsored scheme under the livestock with the disease control program in different districts in Assam. This is to state that the rates as offered by the during negotiation in presence of the bid process management committee on so and so for operationalization of 181 mobile vehicle units with call center in Assam for a period of 5 years under centrally sponsored scheme so and so in the Animal Husbandry and Department Assam is accepted subject to approval revised proposal Government of India. The terms and conditions as per the tender document specification and in accordance with the negotiation right. Further, this LC is initially agreed for 1 year to further extendable on yearly basis on satisfactory evaluation of the performance of parameters. Measure so and so service is required to give its acceptance along with performance bank guarantee amounting to 5% of annual value for the satisfactory performance of the contract in due course after approval of the
Yes,
revised
okay.
proposal by the Department of so and so.
Yes,
Lordship,
Now, my lord.
the other case is already there in the list today. So there is already interim protection. So Lordship, direct this matter to be tagged with that one and giving the same interim relief, because on the same day, when the interim order was passed, the order was signed before the interim order reached the
okay.
office.
so no further action should be
No,
taken.
Nothing has progressing.
No, other action has been taken. I will place it. My lord. They have given it to them.
No, no,
Uh,
no, no.
Work has not started, Lordship.
No, you see, this is for supply of the vehicles or what is it? You're going to buy the vehicle?
Operating the vehicles, some vehicles are belongs to the department.
Oh, vehicles are belong to,
Already purchased, Lordship.
already purchased. So operation of the vehicle.
Operations, Lordship.
No, my lord, if your lordship tag the case, I have no objection.
No, you see, one thing, when you see the order, order was passed on 1/3/2023 by this court. Now, this order has been issued one day earlier, it appears.
Because that is the matter of dispute in that case also.
But as Lordship may take it from my mouth, Lordship, the department I am
Will not operate.
They are not in operation. That's why they are giving us pressure that let the matter be heard.
Let it be clarified in the.
Nothing is progressing. No work has been started.
Let it be clarified what has.
No, so the AG is saying that they have not started working on the contract. So the vehicles are not operational, not being operated by the respondent. So we'll dispose of the entire writ petition.
The Lordship may not be pleased to dispose because this impugn order, which was given, issued on 3rd, it was not challenged in the other case. So this will have a.
The
hearing.
question of challenging that. does
That
not
is why
arise.
it may be tagged with the other one. This is a consequence alone.
Okay, anyway.
But what learned advocate said that may be.
Yes, we'll record all that. Right. Where is the order sheet? Heard Mr. A.K. Bhattacharya, learned counsel for the petitioner.
In the other case, we filed an affidavit that will cover this case also.
Okay, who submits that this court in its order dated 1/3/2023 passed in WPC 1842 of 2023 had directed that no further process should be undertaken with regard to the e-tender notice dated 16/12/2022, whereby 181 numbers of mobile veterinary unit vehicles were to be put into operation for execution of a scheme by the state of Assam. Full stop. However, despite the said order dated 1/3/2023, passed in WPC 1169/2023, the director, AH and Veterinary Department has issued letter dated 28/2/23 to the respondent number 6. And has issued a letter of approval. A letter of award dated, has issued a letter of award dated 28/2/2023 to the respondent number 6. Accepting the quotation submitted by the respondent number 6. And requiring the respondent number 6 to give his acceptance along with the performance guarantee. Next paragraph. Mr. D. Saikia, the learned AG, Assam, assisted by Mr. B. Govai, submits that the 181 numbers of mobile veterinary unit vehicles have not been put into operation in pursuance to the e-tender notice dated 16/12/2022 in view of WPC 1169/2023 being sub judice. Now, in view of the subject matter in issue being sub judice in WPC 1169/2023. He also submits that the state government has already submitted their affidavit in a position in WPC 1169/2023, and the same can also be used as a state affidavit, state government affidavit for disposal of the present case. In view of the submissions made by the counsels for the parties, list this matter along with WPC, tag this matter along with WPC 1169/2023. It is also directed that till the next returnable date, till the next date, no action should be taken by the respondents in pursuance to the letter dated 28/2/2023 issued by the respondent number,
Six. No, I'm sorry.
respondent number 2.
The director,
That's point number 2.
should it be fixed on lordship 11th of April, lordship?
List the matter on 11.
Yes, highly
Let
obliged.
it come after Bihu Miller.
Lordship has already tagged it.
Yes, I've tagged it.
Already tagged.
That case is
It is
They-
before another court today will inform it and both the cases will come together on 11th.
11. After Bihu,
Because it is, we are, because these vehicles are getting, we have some urgency, lordship. If you, highly obliged, lordship.
Let's say petitioner has been awarded a contract, in class 1 contractor at a railway authorities for construction of railway embankment, minor bridge and other things.
Construction of
Minor embankments and railway minor bridge and other things in 2012. For rupees, lordship will find at page 25. For rupees, lordship 18 crores. It had appropriate 18 crores. Lordship got it.
unreadable this, why don't you give a proper copies?
In the heading, lordship, approximate value of the work.
Hmm.
18 crores, 80 lakhs, 98,000 to 82.35. Now, lordship, cases like this, lordship. After that, lordship, it should be completed with a specific period. Petitioner could not complete their work within time. Thereafter, lordship, extension has been given up to 2021. Petitioner has thereafter, lordship, they have issued notice and canceled the work order. And they want to, lordship, encase the bank guarantee. Injunction has been issued by the honorable court and that is pending. And regarding cancellation of the contract, petitioner has approached that as per clause of the agreement, there is the arbitration clause. So it should be referred to the arbitrator. Ultimately, this court has allowed the arbitration agreement. Accordingly, arbitration proceeding is going. Hereafter, lordship, suddenly petitioner has given a notice that petitioner have to pay, lordship, royalty for forest royalty of rupees 10 crores and all.
Forest royalty.
Forest royalty 10 crores and all.
Given by whom?
By the forest department and thereafter by railway.
Given to you by the forest department. So-
Hereafter by the railway. Railway is issued that will deduct from your bill the 10 crores demanded by the forest department it will be deducted from your pending bills. My submission will be, lordship, I have not obtained any lease from the forest department for extraction of minor minerals as required for construction of the railway works. I have no agreement, lease agreement with the forest department. I have not executed any agreement with the forest department and I have get the supply from suppliers regarding materials to be required. And thereafter, lordship, I have executed the work. I have no agreement with the forest department.
No, you might not have any agreement with the forest department, but did you extract?
I have not extracted, supplier has been made.
Supply has been made by whom?
Supplier. There are supplier, lot of supplier who has the lease agreement for extraction of the minor minerals with the forest department. Lordship, thereafter, lordship,
The suppliers have supplied it to you.
lordship. Supplier has supplied to me and thereafter, lordship, I have so much of completed. Now, lordship, the forest department has given a notice. Lordship will kindly see. Now, railway authority pays 75. Page 71 is the initial by the forest department by the divisional forest officer, AC Valley, I Valley, lordship. Page 71.
My lord, before going on to all these facts, my lord, I have an objection, my lord, this writ is not maintainable, my lord.
because my lord, to invoke jurisdiction of 226, my lord, remedy has to be public law remedy, my lord. What remedy is being sought is a private law remedy. Apart from that, my lord, contract has to be statutory, because my lord, I can show, I have citations to quote, my lord, this statute, this is not a statutory contract, but just because you're building a public utility, my lord, it will not lie. It will be purely governed by the civil law and by contract law, my lord. Lordship, I'll go to that. Lordship.
Mental
Lordship will
issue, I
kindly
will
say, no, my lord.
They can argue.
This has to be- this has to be-
I will
This
give
has to be
the
decided first, my lord. Is it
No,
maintainable?
so let him make his submission
Yes,
first.
yes, he can argue. Lordship. Yes. Page 71 is the Lordship demand.
Okay.
Page 71 is the demand. Lordship, total amount, Lordship will find. Last portion, total 10 crores 37 lakhs. Lordship got it. And all.
Yeah.
Copy has been given to me, Lordship. This was letter written to the deputy chief engineer and a railway. 10 crores and odd, Lordship, if forest royalty, they have demanded. And that has been communicated to the deputy chief engineer and a railway. In respect of the work executed by me.
Yes.
Lordship, thereafter, Lordship, the forest department, after receiving the forest department letter, railway authority has issued a letter to me, Lordship. Lordship will find page 75.
Yes, page 75.
Page 75, dated 19/3/2023, Lordship.
Yeah.
In reference to the above, during execution of work, you have utilized the forest material in the above mentioned CA. Meanwhile, correspondence were made with you submission of FRCC for clearance of the final bill, which is yet to be received from you. Hence, you are once again requested to submit the details of the forest royalty clearance amount already paid to the concerning forest department till date against the forest material as stated above, so that balance forest royalty amount can be assessed and paid to the concerned department by the railway itself. In case failed to submit the above mentioned payment documents within 4 or 5 days, that is within 25/3/2023, necessary amount in terms of the FRCC will be paid to the forest department for the available bill of Iman Railway based on the documents with this office. If no document is found to be available in the office record, payment to be done for this office. If document entire and quantity you have executed in this contract as per record and measurement of MB measurement book. Now, Lordship will find last portion, page 76. During meeting with the forest official, it is told that FRCC will be issued contractor immediately after depositing the due. And if not done, if deposited before 31st March, in case of non-depositing contractor will be penalized with 200% penalty. This is the Lordship, I have challenged this letter. In this particular case, Lordship,
Look, this is with regard to payment of royalty, whether you are to pay, someone
No,
else to
Lordship.
pay, why should this court be?
Lordship. this point has been arise in similar situation before the division bench of this honorable court in case of railway. And single bench of this honorable court has also decided the case in a similar situation that when supply has been made from suppliers, the materials has been supplied, got supplied from other suppliers and executed the work, the supplier is to pay the royalty, not by me. And if there is a contract agreement, if there is no specific clause in the contract that I,
But which supplier has supplied you?
Lordship, I have to give details to them. I'm giving the details to them. Lordship will find this court has division bench of this honorable court, and therefore single bench has said that when there is no agreement in the contract agreement, there is no clause that I should give the forest clearance certificate to the railway authority. Railway authority cannot deduct my liability. That has been settled by the division bench, and that has been affirmed by the single bench of this honorable court. Lastly, this is a judgment passed by this honorable court. Lastly, on reported in 2020, 487. This is Lordship in Arunachal bench. I have given the copy, Lordship. It has been categorically held that if there isn't a clause in the agreement,
Where?
I have to mark it in the sentence. It is held in clause, Lordship will find para 11,
The single bench judgment or the division bench judgment?
single bench. That has been relied by the division, single bench judgment, Lordship.
Yes, para 11 what?
Lordship. To mitigate the grievance of the public work department, they are not aware the source from where the contractors has produced the minor materials for the construction of work. In such situation, the department is not in a position to verify whether royalty has been paid or not. This court directed that henceforth respective contractors, while submitting their bills, would also produce documents voucher from the concerned source from the which the such minerals
of the forest produce have been procured. If such verification would also satisfy the requirement and made under the office memorandum dated 17/6/2000. However, this court clarified that same has to be made as a part of term and condition of the agreement that department would like to enter with the respective contractors while said finding of the writ petition was disposed of. It is held until and unless stipulation in the OM is part of the contract or in the contract condition, the employer PWD would be entitled to realize the royalty of the forest produce. Though preamble certain contracts provide AGST forest royalty, including undercharges levied by the forest department or the forest product can be deducted by the employer department from the contractors. Be later said clause being found only preamble of the agreement, not in the terms and the condition of the agreement, same cannot be treated as a binding clause, as preamble of the agreement is merely indication of the subject matter of the agreement, not binding of the clause of the parties. And this has been relied on, Lordship, this division bench judgment. Para 14 now, Lordship. The judgment of Muslim Ali, that is the division bench, Lordship, Supra, make it clear that in absence of any contract condition, recovery from contractor, sub-bill cannot be made against the forest royalty. Regarding OM dated 76 issued by the finance department, it was specifically held that such OM ought to be specifically incorporated as one of the contract conditions to enforce the same or to take benefit of the same. Otherwise, the same is not permissible. It was concluded as per provision of mines and minerals in the responsibilities of the mining lease to make payment of the forest royalties. It is not obligation to be discharged by the contractors in absence of any specific provision incorporated in the contract. Such views are affirmed by the Honorable Division Bench in the Mothers, Trinan Associate and all subsequent decisions of the court in the bench decision of Muslim Ali has thoroughly been followed. Muslim Ali, Lordship, I have given Muslim Ali also. 17 number paragraph, Lordship. 17. We are in agreement with the views expressed by the learned single judge. No appropriation of money from the contractor's dues is permissible unless backed by statutory provision by express provision contained in the contract or agreement binding between the parties to the contract. In absence thereof, no such direction would be such direction would be unauthorized. Learned counsel for the appellant have not been able to show any such provision pursued to make a different view. In view of the above, we find no merit in the appeal. Appeal is accordingly dismissed, but without any order. Single bench judgment has been challenged by the authority. So there is no contract or agreement. I have get the supply from the suppliers, and I have no agreement with the forest department for extraction of the materials. Also. It is the duty of the supplier who has supplied me the materials. They have to take permission. They have to give advance payment by e-salan for procurement of forest goods from the forest mahal. I am not taking any mahal. I have not taken any lease from the forest department. How they can Lordship extract? As per clause 9 of the Lordship, the Forest Royalty Act also, this court has authorized, the act has authorized the person who has taken the lease from the forest department. I have not taken the lease from the forest department. Lordship, if it happens, Lordship, if a man construct a building and taking materials from forest department, then they will come that we should give the salan and other things for construction of a building, Lordship. It is an absurd thing, Lordship. Lordship, clause 9. Section 9. Lordship, the Mines and Minerals Development Regulation Act 1957, Section 9.
Just a minute. I don't have section 9.
Well, I am giving my books. Lordship will not trouble your Lordship with this. My lord, that section 9 is not applicable. That act itself shows, my lord. Section 14. 5 to 13 are not applicable, my lord.
Lordship. They are
Not
they have
applicable,
ample scope to argue the case also. Section 9 also. Holder of a mining lease granted
Just a
before
minute,
commencement of the act.
Just a minute.
Holder of a mining lease granted before commencement of the act shall notwithstanding anything contained in the instrument of lease or any law for that.
1 minute, let me
No,
get
sir.
to the
I
page.
have no lease, Lordship.
Let me get to the page which you are reading.
Lordship will
Page 13.
page 13.
Yes.
The holder of a binding lease granted before commencement of the act shall, who notwithstanding anything contained in the instrument of lease or in the lot for commencement of pay royalty in respect of any minerals removed or consumed by him or by his agent, manager, employer, contractor, or sublease from the lease area after commencement of the rate for the time being specified in the second schedule in respect of the minerals. So I am not the leaseholder, Lordship. As per schedule, the subcontractor who has taken the lease for extraction of minerals. And secondly, Lordship, I have given the Lordship a gazette notification where Lordship the quantity of minor minerals and everything has been quoted. 5 Lordship. 5(2). The contractor engaged for works project of the government department, agencies shall be granted mining permit to be required quantity in the specified in the detailed project report for execution of the works projects for making an application under sub-rule 1 above. I have not obtained any lease though. So how they will realize from me, Lordship?
That's all. Yes.
My lord, that MMDR Act, my lord, they are harping on 9. His lordship will come to section 14. 5 to 13 are not applicable in states, my lord.
Just a minute. The provisions of sections 5 to 13 shall not apply to quarry leases, mining leases, or other in respect of minor mineral.
MMDR categorizes, my lord. This act
Yes, you
categorizes, yes. My lord, this act categorizes minerals into 2 parts, my lord. One is major, which is, my lord, this nuclear power things, my lord, coal, and my lord, this kind of thorium, my lord, this kind of things. And this, my lord, we are dealing with, my lord, minor minerals, which is earth, sand, my lord, stone. These are minor minerals. So that provision which they are harping, that is not, my lord. I'll see, my lord. This sections don't apply.
So
this
what
state.
relevance is it, does it have in this
So
case?
section 9, they are saying that royalty has to be paid by the lessee.
Ah.
But this indicates that lessee it is speaking, it speaks of my lord holders of lease who are my lord extracting major minerals, not minor minerals, my lord. There's an exception carved out, my lord. And that apart, my lord, I was raising.
No, his basic question is that he has not been extracting those things.
No, exactly, my
They
lord.
have
We
been
understand
extracted by some
Understand.
other person, they are
My lord,
buying
we
it from
only-
their
no, no,
supplier.
The word used is supplier. No, my lord, he has to procure, my lord.
Is it procure?
He has to procure, and only that
Procure
procurement-
from the supplier.
Yes, procurement, and that source, my lord, he has to show that source is, my lord, royalty paid. That's all, my lord.
He has got to show that the
Yes,
royalty has
he has
been,
to come with the
has-
vouchers. Yes,
that the royalty has been paid by that agent
yes, my lord.
or that,
That source is legal, my lord.
so where is that provided here?
And apart from that, my lord.
No,
we have-
where is it required that he has to show that he has procured it from a
Legal source.
supplier and that supplier has paid all the royalty? Where is it?
The bid document, my lord,
Huh?
my lord, they have not annexed. Bid document, they have not annexed.
Oh, they're not.
Not annexed. And apart from that, my lord, I was raising the issue of mental.
I don't know. Then you produce the bid document.
And apart from that, my lord, I'm handing over a few citations. First is, my lord, 2000 volume 6 SCC 293. Well, sorry, I have wrongly given my, no, my lord can take it, but it is with colored. You color, if color pencil has been used. My lord, the Kerala Electricity Board, para 10, my lord.
Para 10, my lord, it's, we find, my lord, can I read?
Yes,
We find that there is a merit in the first contention of Mr. Raval. Learned counsel has practically questioned the maintainability of the writ petition, the interpretation and implementation of a clause, my lord. Of a clause in a contract cannot be the subject matter of a writ petition. Whether the contract emphasizes actual payment or not is a question, or not is a question of construction of contract. If a term of contract is violated, ordinarily the remedy is the writ petition on the is not the writ petition on 226. We are also unable to agree with the observations of the High Court that the contractor was seeking enforcement of a statutory contract. A contract, my lord, would not become statutory simply because it is for the construction of a public utility and it has been awarded by a statutory body. We are also unable to agree with the observation of the High Court that since the obligations imposed by the contractor on contracting parties come within the purview of the Contract Act, that would not make the contract statutory. Clearly, the High Court fell into error in coming to the conclusion that the contract in question was statutory in nature. 11. A statute may expressly or impliedly confer power on a statutory body to enter into contracts in order to enable it to discharge its functions. Dispute arising out of the terms of such contracts or alleged breaches to have to be settled by the ordinary principles of law of contract. The fact that one of the parties to the agreement is a statutory or a public body will not by itself affect the principles to be applied. The disputes about the meaning of a covenant in a contract or its enforceability have to be determined according to the usual principles of the Contract Act. Every act of a statutory body need not necessarily involve an exercise of a statutory power. Statutory bodies like private parties have power to contract or to deal with property. Such activities may not raise any issue of public law. In the present case, it has not been shown how the contract is statutory. The contract between the parties in the realm of private law, it is not a statutory contract. The disputes relating to the interpretation of the terms and conditions of such a contract would not have been agitated in a petition under 226 of the Constitution of India. That is a matter of adjudication by the civil court or in arbitration if provided for in the contract. Whether any amount is due or if so, how much, and refusal of the appellant to pay it is justified or not are not the matters which could have been agitated and decided in the writ petition. The contractor should have relegated to other remedies. Secondly,
Joseph, we have no agreement with the forest department.
Joseph
We have agreement with
Technologies.
the railway authorities. They are arguing on behalf of the forest railway authority.
they are agreeing with. What did you say?
My submission of the bill, Joseph, we have made a contact with the railway authorities, not with the forest department. They are arguing regarding contract. We have no contact with the forest department, Joseph. We have contract agreement with the railway authorities.
Well, he adopts. It's for the railways. I'm submitting on his behalf. My lord, that Joshi Technologies, my lord.
Yes,
Joshi Technologies.
yes.
Para 69, my lord. Before 69, my lord, I'll come to para 56. 56. Significantly, 56 started significantly, my lord has found, my lord.
Yes.
As well as this court made it clear that if rights are purely of private character, no mandamus can be issued. Thus, even if the respondent is state the other condition which has to be satisfied for the issuance of a writ of mandamus is the public duty. In the matter of private character or purely contractual field, no such public duty element is involved, and thus mandamus will not lie, my lord. And also, my lord, from 69. My lord has found. The position does summarize, my lord. In the aforesaid principle has to be understood in a context of discussion that preceded which we have pointed above. As per this, no doubt, there is no absolute bar to the maintainability of the writ petition, even in contextual matters or where there is a disputed question of fact or even when monetary claim is raised. At the same time, discretion lies with the High Court which under certain circumstances it can refuse to exercise. It also follows that under the following circumstances, normally the court would not exercise such a discretion. 69.1, my lord. The court cannot examine the issue unless the action has some public law character attached to it. 69.2, my lord. Whenever a particular mode of settlement of dispute is provided in the contract, the High Court would refuse to exercise its discretion under 226 and relegate the party to the said mode of settlement, particularly when settlement of dispute is to be resorted through by means of arbitration. 69.3, my lord. If there are serious disputed questions of fact, which are of complex nature and require oral evidence for the determination. 69.4, my lord.
No, no,
Money
okay,
claims per se.
okay. You see, the thing is that his case is that he has got no. He does not need to pay any royalty. That's his case.
My lord,
And have you given him notice with regard to the thing?
He has been given notice, my lord.
Did he reply?
Yes.
Lordship in the page 75 lordship, it is itself, it is categorically stated lordship.
Page 75.
Lordship, in many occasions, lordship, he failed to give any clearance, forest royalty clearance certificate, lordship. We have been intimating in lordship and
Where is your notice to him?
lordship, that has not been annexed, lordship, in the petitions, lordship. And moreover, in the, it is.
No, have you been given any notice with
Notice
regard to the
letter.
royalty?
This letter, okay, kindly, this is the page 71. That is demand notice. Given to me,
So
Lordship.
have you given any reply to this letter?
Lordship, I have given reply stating that
Where is your reply?
reply, Lordship will find. Page 72, Lordship. We have stated that as per mineral schedule of 2012, it should be given. And I can produce it from the supplier also.
Just a minute. I'll come after 1 minute.
my lord, yes, my lord, I'm not done with this Joshi. I'll again,
Huh?
I get trouble with lordship with this Joshi technology. I'm not done with it. Lordship. Okay.
Lordship will find that agreement is executed between the petitioner and it's on behalf of the President of India. President of India. Railway has authority has signed this agreement on behalf.
You see, you have got this problem with the railways. You have got arbitration. Why aren't you going for arbitration?
Arbitration I have done, Lordship.
No,
And
no,
this is the order-
arbitration has,
Regarding cancellation. Regarding cancellation.
Huh?
Matter is in the session of the arbitration, lordship.
Regarding
so
cancellation.
this issue also, why can't it go before the arbitrator?
Because the subsequent issue.
It
Subsequent issue.
is, no, it is part of the contract.
No, part of the contract, but this has been issued subsequently after referred with arbitration.
No, it might be, but then
Lordship, can you see the-
we can send this to arbitration. also.
Lordship, till then it will stay, Lordship.
Huh?
Till then it should not be recovered. Page 69 is the arbitration notice.
Till you go to the arbitrator, it should not be
Lordship,
recovered.
Lordship.
Till you go to the,
Lordship, the thing is that lordship, my submission will be lordship, they cannot in any sense, lordship, they cannot say that loyalty is not required. In any case, lordship.
no,
either-
royalty
either
has
the
to be
supplier-
paid. The question is who has to pay it.
We are just
Exactly.
asking them to show
The vouchers, lordship.
collected from a legal source.
Yes, lord.
You come with vouchers, you show that you.
Yes, you have got to show
Exactly, lordship.
who
That's
from
all.
who you have collected.
Yes.
In any case, lordship. forest
So where
department
is
has to be paid with the
Lordship,
lordship.
I
Where is that in your
I
writ
have to, I
petition?
have to
No,
contact.
Mr. Counsel. Yeah, when you come to court, you have got to show this court that you have collected all those materials from a source.
Supplier,
From,
supplier.
yes, from a supplier who has given royalty.
Lordship,
Now,
I have given a statement in the petition.
no, you give your documents. Where is your, when you buy something from someone, how do you buy it? By word of mouth? Or how do you give payment to that supplier?
Lordship, it's supplier, Lordship, by check, we have paid the amount. There is some.
By
cases-
check, you have paid the
by
amount.
check, we have.
So
paid
where
the-
is the check?
Lordship, already a lot of cases are pending regarding these checks in different courts of Kachar.
Mr. Counsel, I'm not bothered about different courts. I'm not bothered about different cases. I'm only interested in your case right now before me.
Lordship,
Now,
can-
in
I
this case, where is your
Lordship, these-
document?
this notice has been issued on 25/3, Lordship. 25/3. How can I produce everything from collecting from the context of
Lordship,
4 days?
the
Lordship?
first
no,
notice
you
was
should
issued
be-
in January, lordship.
Huh?
First notice was issued in January. lordship.
Last letter, when they have said that it will be deducted from my.
You bring all the documents, we'll see.
Lordship,
You submit all the documents
Lordship,
that you have.
we'll give the details, Lordship.
Ah,
We'll
you
give the
give,
details,
you give?
as far as possible details from the supplier.
No stay, but.
But
No
no
stay,
stay.
isn't it?
No, not to recover this moment, Lordship. If
No,
will
they
deduct
won't
from the
recover, they won't recover. You don't recover.
Lordship,
I will not give
record-
any stay, but you don't recover.
Not record, lordship, let them show the vouchers,
Huh?
lordship. Not recorded, lordship, but I will assure.
Yes, you assure them that it will not be.
That way recorded, Lordship.
I'll-
Submission be recorded, otherwise, Lordship, they will deduct
My
everything.
lord, he comes to the court without annexing the contract document. Now he wants a, my lord.
Contract agreement, I have annexed,
From
Lordship.
us, that my lord, we will not recover.
Where is the contract document?
Lordship, agreement at page 25.
Page 25.
That is not contract document.
Agreement for work, Lordship. That has been given to us.
That is
Everything is with the relay authority.
regarding the
Let them
royalty
produce the
clause.
relay authority
The
document,
contract
Lordship.
document, Lordship, in the.
Where is the agreement?
Agreement is, Lordship, will find page 25. Page 25. Agreement of work.
Relevant extract of the contract agreement and the.
That is the main code.
Right. Mr. S.K. Goswami, learned counsel for the petitioner, submits that pursuant to an NIT What is the NIT date?
Lordship will kindly see page 25. This is a contract agreement for the works.
Where is the NIT?
That is the main document.
That is the main issue, my lord. Because.
Tender notice,
clauses
Lordship,
are
will
there.
find at my letter, Lordship, page 21. Tender number Iman, dated Iman, Lordship.
Mr. Counsel, do you understand the question put forth by this court?
I have not annexed the tender notice.
The clauses have been there.
That's right. Heard Mr. S.K. Goswami, learned counsel for the petitioner, who submits that the petitioner was awarded the contract work of earthwork for cutting and making of railway embankment and construction of minor bridges, RUB and other ancillary works, including protection works. From CH 210/000 km to CH 215/000 km of Bilashipara Chapar section in connection with the construction of new BG railway line project from New Mainaguri (West Bengal) to Jogi Gopha, Assam. While agreement of works dated
12/10/2012.
12/10/2012 for the total approximate value of rupees 18,98,282.35. Due to the petitioner not completing the work in time, due to the petitioner not being able to complete the work in time, the contract was terminated. The dispute between the parties is now before an arbitrator.
Page 69.
Huh?
Page 69 is the
Before arbitrator. Next para. The grievance of the petitioner in this writ petition is that during the pendency of the arbitration proceedings, the railway authorities have demanded a forest royalty clearance certificate from the petitioner showing that he has paid all the forest royalty for extraction of minor minerals. From where?
From the petitioner, Lordship.
Yes, from where did he extract?
Lordship, he will know.
That
Lordship.
is the question.
He will know, Lordship.
That is the.
For extraction of minor minerals. First up. while letter dated, while letters dated,
19/3/2023.
no, before that,
Before that, Forest Department. letter.
21/1/2023.
21/1/23 issued by the Forest Department, is it?
To the Deputy Chief Manager,
Huh? Page
page 71.
issued by the
Divisional Forest Officer.
Divisional Forest Officer,
I Valley Division.
I Valley Division, AIE, huh? I Valley Division. Bongaigaon. And
And that is the letter to the Deputy Chief Engineer.
letter dated 19/3/2023 issued by the
Deputy Chief Engineer.
respondent number 4. Yes, sir. Next paragraph. The stand of the petitioner is that
Petitioner has not taken any lease from the government, Forest Department.
the stand of the petitioner is that the petitioner has not taken any lease from the state government for mining purposes and as such, and has used minor minerals procured from suppliers, local suppliers, from other suppliers. So, accordingly, the petitioner was not required to pay any royalty to the state government, as no mining lease had been taken by the petitioner.
And agreement also do not provide.
Further, the agreement made between the petitioner and the railway authorities did not provide for
Payment of royalty.
payment of royalty by the petitioner for the minor minerals used by the petitioner for his contract work.
That is a submission, Lordship.
That is submission. That's submission. Next paragraph. Mr.
Lordship, DJ Das.
DJ Das appearing for the railways
1 to 4.
for the response number 1 to 4, and Mr. D. Gogoi appearing for the Forest Department
5, 6, 7.
5,
5, 6, 7.
5, 6, 7. Submit that the petitioner should either approach the civil court or an arbitrator, as the matter in issue pertains to private law remedy and not public law remedy. They also submit that there has been nothing annexed to the writ petition to show from whom the petitioner had procured the minor mineral and whether those persons from whom the petitioner had allegedly procured the minor minerals had paid royalty. That's all. They also submit that the NIT has not been annexed to the writ petition. Any other document needs to be annexed?
The whole controversy.
Yes, I think you make, I think you have got to show from whom you have bought all the.
We'll file an additional affidavit enclosing the documents as Lordship asks for us, Lordship. We'll enclose the documents. And they have the agreement, contract agreement with them. We'll take them from them.
Huh?
Because it is his case, he has to prove, he'll bring all the entire contract.
We'll enclose, Lordship. We're taking from the railway authorities.
On perusing the writ petition, this court is in agreement with the counsel for the respondents that the writ petition lacks in material particulars, as there is nothing to show from whom the petitioner had procured the minor minerals for doing his contract work worth approximately 18 crores.
Increase to 27.
In this regard, Mr. S.K. Goswami submits that he will file an additional affidavit within.
After review, Lordship, only thing Lordship can quote the judgment, Lordship. I have quoted the judgment.
No,
of the
no,
exam.
no, that is,
That-
I'm
that
not,
was
I'm
the
not passing any order. Yeah.
Only thing is, Lordship, if I'm not protected, if they are assurance of giving,
No,
Lordship.
no, I will record his submission. Within,
After review, Lordship, after review.
how much, after Bihu
weeks,
means
2
that
weeks,
20,000
2
years
weeks,
can be after
2 weeks,
Bihu also.
2 weeks,
Huh?
Lordship,
2 weeks,
2 weeks,
within 3 weeks,
Lordship.
within 3 weeks.
That's not going to be recorded, Lordship. I'll give assurance, Lordship. I'll intimate my officers. Lordship.
No, I will record your
Yes,
submission,
Lordship. Yes.
your submission
And
only.
moreover, Lordship, the contract, tell you, Lordship, it was thereby increased to 27 crores, Lordship.
Oh.
Subsequently, it is.
So, Mr.
DJ does not.
DJ Das, the head counsel for the railway submits that the contract amount had been enhanced
Because they
to
couldn't
rupees
complete.
27 crore, to approximately 27 crore. So stuff, he also submits that till the next returnable date, he will inform and the railways not to take
Act
any
on-
coercive
not to act.
measures.
Not to act
against-
on this notice.
Will not act upon the
This 19.
letter dated
19/3/2020.
19/3/2023 till the next returnable.
Lordship, because they are getting something, some interim protection, Lordship. That's why I'm paying for a fixed date, your Lordship.
Okay, list the matter on when do you want?
Lordship, any date, Lordship, confidence, to you, Lordship.
April
In the month
20
April, Lordship.
20 or 25th,
Lordship, any date, Lordship.
Twen-
confidence.
Lordship, may,
20,
Lordship may record my one son.
25.
May I submit one thing, Lordship? I may be allowed to liberty to file appropriate application before the arbitration tribunal which is pending within railway authority and us. Pendant shall be barred to approach the,
You file your first, let us see what you have got to file here. You file here first. We want to be, even this court
Contract-
wants to know from
Lordship
who
want
you.
to know the
call-
contract
from-
ag- Lordship want to know the NIT contract
No,
agreement.
no, just right. The petitioner shall submit the additional affidavit specifically stating as to,
Name of the supplier.
as to the amount of minor minerals procured from his suppliers
Already, Lordship, the amount has been mentioned in the letter.
and the names and addresses of those suppliers.
Name of the supplier.
Name and addresses
Name address of the supplier.
Lordship, the
along with all vouchers and bills.
Lordship, the maintainable issue may be kept.
The maintainability of the repetition is kept. The maintainability issue of the repetition is kept.
May I submit, Lordship? Lordship has already pointed out that arbitration proceeding is pending. 120 days will expire, Lordship. If that, Lordship, that is why we may also give in liberty to approach the,
You first file your affidavit. The court wants to know also from who you procured.
we'll give the name by affidavit, Lordship. We'll give the name from the supplier from who we have taken, Lordship.
After that, we'll give you liberty to go there.
No, Lordship, actually 90 days notice has to be, 120 days notice has to be given under section 9 of the Arbitration Act. So that will not cover up, Lordship. That's why we're asking the liberty, Lordship. Liberty is
We'll
given
give you
to
liberty next day.
Lordship.
Oblige.
Yes,
Actually, I'm handicapped, my lord. I'm not a standing counsel. I'm only a panel advocate, my lord. So until
Okay,
I
yeah.
get instruction, I cannot appear, my lord. But if your lordship thinks I can convey the matter to the bank,
okay. What we can do is we can list it next week if you want.
my lord,
You can convey, you see, prima facie, they want 6 months, 3 months time.
my lord.
So, this court was thinking that 3 months time may be given
My lord.
as a thing.
The amount which they have said is 6 lakhs. It is not 6 lakhs, my lord. Outstanding amount is 55 lakhs, my lord.
Oh,
No,
Outstanding
no,
amount is
Lordship.
65 lakhs, my lord.
No, Lordship. Two, three. as
Annexure,
per their-
annexure 9, page 70, lordship, if your lordship goes through. Letter dated 4/3/2023.
Paragraph two. Lordship.
On the top, it is written my outstanding amount. Outstanding amount, my lord. I've got it.
yes,
This is the entire outstanding amount, my lord.
Irregularities.
And apart
for
from that,
2, 3
this,
Yeah, present outstanding 55, 81,
my lord,
840.
my lord, my lord.
But irregularities as per this letter, irregularities for 2, 3 months.
This
Lord.
is regarding the latest EMIs which they have defaulted, my lord.
Yes, Lord.
So you'll pay this 55 lakhs within 3
No,
months.
no, it is not 55 lakhs, Lordship. As I'm instructed, Lordship, because irregularities of 2, 3 EMIs, Lordship.
Hmm?
Irregularities of 2, 3, Lordship.
Look, we can only go by the documents that are here.
Yes.
We cannot go into the merits. The SARFAESI Act is a special act is there.
Yes, but Lordship, may I read if I have not understood? That's on scrutiny of account, we have found that you have not paid EMI in full. Rupees 1,60,000 in your TL account number so and so for last 2, 3 months. The EMI for month of November 22 has been paid by you on 3/12/2022. However, the EMI for the months of December to February is overdue. This is the information, and I'm informed by my client also. Irregularities of 2, 3 months. Lordship, I am facing very hardship even tomorrow, today morning also. Their recovery van is ready to seize my entire machines, Lordship.
Okay, right. Heard Miss
And
M. Bora, Learned Counsel for the petitioner. To submit that the petitioner is a partner of a partnership firm under the name and style of MS Assam Healthcare Diagnostic Center. The petitioner's firm obtained a term loan from the respondent bank, which was sanctioned on 22/12/2020. Due to the COVID-19 pandemic, the firm of the petitioner has suffered severe financial loss, and due to which the account of the firm has been recorded as a non-performing asset, bracket NPA, on 10/3/2023 for default of almost, what do you mean almost?
Lordship, they have,
Of almost 4 EMIs,
Lordship,
including interest amounting to rupees 6,67,000. Next paragraph. The petitioner's counsel submits that the respondent bank has issued notices to the partnership firm asking the petitioner to deposit the entire amount of how much?
Lordship, they have not specified.
The entire due amount.
EMI.
Due amount by 29/3/2023. Failing which the bank would take action against the partnership firm under the SARFAESI Act. Which would lead to seizure and sale of the assets of the partnership firm. The petitioner's counsel submits that the petitioner has filed a written reply dated
15 March, Lordship.
15/3/2023. Praying to the respondent bank, praying for 3 months' time to repay the entire due amount. However, the respondents have not made any reply to the petitioner's representation. Dated
15/3, Lordship.
15/3. So should we allow the writ petition straight away?
My lord,
Should we allow the writ petition straight away?
Because lordship, the amount is 55 lakhs.
Lordship,
Is quite a huge amount, my
whatever
lord,
may
because
be
bank will
amount,
not come
Lordship,
to,
I will pay within
because my
3
lord, the
months.
bank will not come for the, to recover the assets for a 6 lakhs rupees, my lord.
That is my case,
Because
Lordship.
that's
For
why
a
they have
lump
written the
sum
outstanding,
amount,
because these are the, which is letter, they have mentioned in the letter regarding the 3 EMIs. These are the latest EMIs, my lord. Earlier also he has defaulted, my lord. Now, when these 3 EMIs have been defaulted continuously, the account automatically is classified as per the system, automatically it is classified as NPA.
bank for
In earlier occasion also, he has failed to pay, my lord.
71.
So this amount is quite huge, my lord. 55 lakhs is not a matter of joke, my lord.
Lordship, if I undertake, Lordship, if I fails to pay the entire amount within 3 months, bank. are
Because bank
required
will
to
not
do
come, my lord. What he is
everything, Lordship.
telling that yesterday the bank officers came and bank will not come without any letter. Yesterday, what letter they have given? Bank has not given anything yesterday, my lord. If they come to recover the assets, at least some communication will be there that we have come to recover your asset. So that they have not enclosed in the writ petition.
No,
my lord.
that is why I'm saying 3 months time, they want to give them 3 months
3
time.
months time will be too much, my lord, because that I cannot.
Already half a month has gone. No, yes, already, no, today is what date?
Today is 30.
30, so half a month has gone already.
2 months, my lord, lordship can give 2 months.
Should I reflect your presence?
No, my lord, I cannot try. Or lordship may remand the matter to the dispose of the representation which they.
Yes, yes.
53.
I
That
think
will be
that
the
them,
best thing.
until then, no
Lordship,
decision.
Until then, my lord,
Next, huh?
Lordship, they will not.
the lordship may give a time
Even-
frame.
No, we'll give them a time frame.
Within which they will dispose this letter, my
They,
lord.
they
And
should
such-
dispose of this
No
letter
corrective
within a
action will
month.
be taken,
Until then, no action should be taken
my
against
lord,
them.
Lordship,
Okay, then you can come again.
my lord.
Next, on considering the on considering the fact that the petitioner's representation dated 15/3/2023 praying for 3 months' time to repay the entire due amount payable by the petitioner to the bank has not been considered by the respondent bank. This court is of the view that the petitioner's representation needs to be considered and a decision taken on the same. Full stop. Accordingly, in view of the above facts, the respondent bank is directed to take a decision on the petitioner's representation dated 15/3/2023 for giving the petitioner 3 months' time to repay the entire due amount to the respondent bank. The respondent bank shall take a decision on the petitioner's representation within a period of shall take a decision on the petitioner's representation and communicate its decision to the petitioner. Full stop. Till the decision taken by the respondent bank is communicated by the respondent bank to the petitioner, the respondent bank shall not act upon the impugned letter dated,
Lordship. 15 last.
Huh?
15.
not 15/3, the respondent bank's letter
It starts from
shall not act upon the
last letter, Lordship.
shall not take any coercive action against the petition.
That letter may be mentioned, my lord. This demand was made by the bank. I think 4/3 letter dated, my lord.
Huh?
That letter dated 4/3, my lord, when the
4/3,
bank had
lordship.
made the
Page-
Where is that
Page se-
page?
Page
Page-
70, Lordship.
70,
17.
70.
70. There are several letters, 43, 53,
No, there are several letters, that's what,
Several
there are too many, there's 4-3, there's 15-3, 16-3.
Yes, Lordship, so is
Okay,
letter
so
here?
submitted.
No coercive.
Lordship, may I?
And one more. Wherever you find the letters, we have said, no, respondent said letters, the dates are here in the synopsis.
Mhm.
The dates of the letters are 10-23, 24-23, 4-3-23, 15-3-23, and 16-3-23. The writ petitions are accordingly disposed of.
Lordship,
So hopefully they'll take more than 2.5 months' time to decide.
Lordship, may I pray for a certified copy of this order today itself? I am. Lordship.
It will come out in the website.
Lordship.
Yes, ma'am. It will come out.
Obliged.
Lordship, in this case, the case was listed day before yesterday, Lordship. So a prayer was made on behalf of me for filing the affidavit, Lordship. I have filed the affidavit today, Lordship. To the affidavit filed by the respondent number 5. And the private respondent has also filed the affidavit. So Lordship may fix the matter any day next week. I'll come up with the affidavit. that is-
You can argue now.
No, Lordship, the affidavit, let the affidavit come on record.
Why? You
I-
tell me, I'm ready, you tell me.
No, lots of that. I have annexed certain documents there, lots. So, and, but any day next. week. So
You see, his case is that the contract works have been completed.
But we have been protected by the first order of this honorable court, lots. The contracts were awarded to the private respondent are subject to the outcome of this honorable.
Subject to the outcome means what?
Lots of-
Once it has been completed, then that's the end of the
lots of
matter.
Whether the.
So now they will work, but you'll get the money, is it?
lots of-
Well, how are you going to
No,
be
no, so
protected?
whether the initial decision of giving the contract, allotting to the contract to the private respondent, that was.
That is
properly-
all now of academic interest only.
No,
How
no.
does it matter?
Lots of, let the matter come any day next week. Lots. Today I have filed. I have submitted the copy to the respondent. Today I already filed.
But why do you want, what is there to decide?
No, lots of, and let the matter.
You tell me, you give me an idea, what is your case?
No, no, my, okay. Let the affidavit come, lots of, lots of may take it tomorrow also, indicating that affidavit may be put on the.
My problem is
No,
that
no,
my lord, that
lots of
tomorrow is the
keep it-
last day.
Last date for what?
For my lord, that entire amount will be my lord, the last, my lord, it will be.
No, no,
Yes,
that-
yes.
No, that is not the issue, lots. The municipality is a autonomous body, they are having their individual fund also. They are not dependent on the government. fund.
There is no bar for releasing of payment, my lord.
Huh?
There is no bar for releasing of payment, my lord. We are for exponent, my private exponent, my lord. There is no bar for releasing of payment, my lord. Let me see our payment. Lord, may decide if you want to take time, you take time, my lord.
This is, you see, unless this issue is decided, they will not get their money.
My lord.
We cannot. Because the financial year will lapse.
But so far my instruction goes, lots of there is no issue like this. Lots of.
No, maybe, but then the new financial year, they'll have other agendas, they'll use the money elsewhere.
Lord, me of that, there is no bar for releasing of payment. Lord, my joint, we have
Oh,
not.
all right.
Lots of they take the matter tomorrow by taking the matter.
Mr. Council, we've got other matters also. Yours is not the only matter. We've got so many matters. You filed the counter affidavit. You're supposed to be the one who's most prepared for the case.
Lots of. But I was out of station yesterday.
But you have filed it today. Then
Today.
what more do you want? Everything is still fresh in your mind. What is your case?
Yes, is there lots of the initially there was a contract, lots of, and the annexer 1.
Initially, there was a notice.
uh,
Initially, there cannot be a contract.
No, sorry, lots of, I'm checking back. Initially there is a NIT at page 20, lots of annexer 1. 22/12/2021, lots of, and that NIT has been cancelled thereafter, lots of.
Yes, then,
Then there is a phrase NIT also at page 24, 2022. And the petitioner participated at with the contract works at serial number 11, 13, 14, 15, 16, 20, 21, and
just a minute. Participated in 11,
11, 13, 14, 15, 16, 21, 20, 20, 21, 22, 23, 24.
Ah.
And thereafter lots of the
so you participated in 10 contract
10
work.
contracts.
Then,
And thereafter after the which were open, lots of comparative statements were prepared, which I have annexed at annex 6 lots. And my bid was rejected only because of the fact that category the petitioner's farm has been categorized as general category lots, whereas the basic reason of rejection was that my
categorized as
categorized as general category.
general category.
General category. And
Where is that?
it has been
Page?
page 37 also. Page 37, the type copy.
Huh?
Page 37 is the type copy lots.
Yes,
And down below lordship, whether belongs to SC, ST, OBC or general.
yes,
First column lordship.
Yes.
General, GNL.
yes.
And the next one also next page at page 38.
RBR. So you are general category.
in lordship. At
So
page-
what is wrong? You cannot be
No,
general
lordship.
category.
No, lordship. The proprietor of the farm is belong to ST category lordship.
Let us see the NIT. Page. Page 20.
24 lordship. That is the first NIT, the subsequent is the 24.
Yes,
Terms and conditions of the NIT is starting from page 26 lordship.
yes.
May I read lordship?
Yes,
Okay. The terms and conditions, the prescribed tender form will be issued in the contractual from the office of undersigned on 29/1/2022 to 5/2/2022 during the office working hours 11 AM to 3 PM. And after submission of the application with bank, draft or tenure fee against the mentioned work done, work by the contractor. The date of submission of the tender is on 5/2/22 from 11 AM to 2 PM. And will be open on the same day at 2:30 PM in presence of the tenderer and on their authorized representative. If the office happens to be closed on on date of receiving of the tenders as specified in the tender will be received and open on the next working day at the same time.
no,
when-
okay, okay, now,
The category, regarding the category, it has been mentioned in terms and condition number 3(1) lordship.
3(1).
Lordship. The tender at page 26. The tenderer should deposit earnest money of 2%, 1% for ST, OBC, and unemployed graduate engineer on estimated value of mentioned venture lordship.
So even a general category can participate,
Lordship.
but he'll have to give 2%
Lots.
amusement.
But in this particular case, the sole proprietor of the petitioner farm lordship, he belongs to ST category. So
Okay, petitioner firm belongs to SC category,
ST category,
ST category, and you gave 1%.
1%.
And you were rejected because they said that you are a
Yes.
general category.
General category.
Okay, so the question is whether petitioner belongs to ST or ST.
ST lordship, that's what I have brought in record through the affidavit lordship.
belongs to ST or
ST.
general category.
Lordship.
That's the only thing.
The only thing, and whether there,
Okay, where is the impugned letter?
no, there is no letter also. in
There's
there,
no, you've been basically rejected.
Lordship.
On-
Basically, it
uh,
has been,
So orally you were told. Orally you were told that since you have deposited only
Yes.
1% of the earnest money,
and,
and
one more
since
thing.
you are a general category candidate,
Lordship.
tenderer, you are disqualified.
And one more thing, Lordship, the work done certificate that has been categorized at page 38, Lordship.
Yes, Mr. Yes, work done.
Work done certificate, that is a new requirement, Lordship. That was that terms and in the terms and condition, it was not specifically mentioned. Lordship. But only
Nothing is mentioned in the work done with regard to work done
work
in
done
the
certificate in the terms
advertisement.
and condition of the NI.
So what happened?
Lordship, the petitioner did not naturally, as because the terms and condition did not contain that particular requirement, Lordship. He did not submit the work done certificate, but he submitted certain work experience along with past experience of work similar nature, Lordship. That is mentioned in 3.4, Lordship. Condition 3.4.
He submitted what?
As per the requirement of the condition 3.4, Lordship, he submitted the work experience along with the details of past experience of works of similar nature. It has been mentioned, Lordship, at page 26, 3 Roman 4. He has fulfilled all the requirements of the NIT. Up-to-date clearance certificate of income, original money receipt or tender fee payment, everything else.
3.4 speaks of the tenderer should submit photostat and attested copy of
The
up-to-date registration certificate of PWD. Do you have that?
Yes, we have submitted.
Then certificate work experience.
Labor license certificate.
Certificate work experience, did you have? You don't have.
Work experience also, work done certificate, he has not submitted also, but work experience certificate, whatever he has done, he has executed certain works under the respondent municipal board.
It says here, it says here,
Lordship,
certificate, then work experience,
work experience,
along with details of past experience of work.
that we have submitted. Lordship.
So where is your affidavit? Where is your experience certificate?
Experience certificate, not experience certificate, Lordship, whatever work he has done during the prior period under the municipal board, Gwalpara municipal board, that work orders he has annexed, Lordship. As per my instruction. And specifically, requirement of the work done certificate was not there in the NIT. Lordship.
Work done certificate, you have not annexed.
No, Lordship.
You have annexed work experience.
Work experience, whatever work he has executed, the
So work experience is what is required. Work done is not required.
Work done means what completion certificate. That's why what I understand. Lordship.
Okay, then, so on two grounds you have been.
On these two particular categories, Lordship, is if we see from the comparative statement, his bid was rejected, though he quoted the lowest one.
Anything else?
These are the things, Lordship, and respondent have come up with their affidavit, Lordship, with regard to that. And they have,
Respondent, private respondent.
private respondent has recently filed a affidavit, Lordship. The respondent number 5, the executive officer of Walpur Municipal Court. They have come up with their affidavit. It was filed on 31/5/22.
So what have they said?
They are bringing in a record certain new notification also. They have annexed with the affidavit. That notification says that at page 7 of your affidavit, Lordship. They and one with regard to the person ID, they say that they have the authority to recall without assigning any reason, Lordship.
So that is not under
Of-
challenge. First
And-
NIT is finished.
And Lordship, they are talking about certain manual for procurement of works 2019, which was issued by the Ministry of Finance Department of Expenditure, Lordship. In that, they are saying that.
No, you see, let us confine ourselves.
No,
What
sir.
they want to say, let them say.
Lordship.
Now, the issue is whether your general category candidate, I mean, a person, or you are a ST.
Lordship.
So how do you prove that you are
I
an
have
ST?
annexed my caste certificate, Lordship, in the affidavit filed by them.
Caste in their affidavit.
Lordship, the affidavit that has been filed today, Lordship.
Huh?
This is a copy, Lordship.
You've got a copy of the affidavit?
My lord,
Affidavit has been served in the office today, Lordship. Because of all the respondents are required to be served nowadays.
And in your bid document,
Lordship.
did you say that you were ST?
Yes, Lordship. As per my instruction, he has stated, Lordship. And
Now we'll see. That's all. Yeah.
lordship, in my affidavit, lordship, I have filed by respondent number 5, lordship, kindly turn to the page 13, annexure E, lordship. We have been
Page?
filed up, my lord, that tender, my lord. In the name of
Annexure?
annexure E, lordship, page 13,
E.
E. The affidavit filed by respondent number 5, lordship.
As per number 5. Ah, yes. Yeah,
Lordship, this is the registration certificate.
yes,
Lordship, my lord, collect on the registration number,
yes.
FPWRD /R/3, Lordship General. GEN.
Ah.
So this
Okay.
farm has been registered as a general, lordship, not as a ST.
Okay, firm has been
That-
registered as a general.
No, no,
category.
no, Lordship. the
But
farm
he,
is-
that's why, my lord, he does not, my lord, enclose the, my lord, that his registration certificate in a deputy.
No, that is on record, Lordship. It is, we have annexed in the, with our tender document. That's why they have received this,
What?
this particular annexure, also annexure E. That must have been annexed with the, along with the tender document. Along with the caste certificate, Lordship.
Naturally.
Caste certificate has already been annexed, Lordship.
My lord, he
And
has
the
not
down
done, my
below.
lord, that tender, my lord, he individual, lordship, he was, my lord, that submitted the tender paper as a, my lord, farm, registered farm, lordship. So in the registered farm, it is written as a general, that's why, my lord, the tender was not by, accepted by the, my lord, concerned authority.
But in the tender, in the NIT, Lordship, that category, whether the farm or individual, that category has.
No,
not been
but then
accepted.
you see, but then you are registered as a firm. You submitted your bid as a firm. Did you submit your tender in your name?
No, Lordship, the down below the proprietor name is there, Lordship.
Maybe,
Kumar Rava.
you
It
see,
belongs to ST category.
maybe, but then you are registered as a general category.
Yeah. farm is an artificial personality, Lordship.
Still, it's a juristic person.
Lordship, but even if the person who is representing the farm, sole proprietor, Ranjit Kumar Rafa, even the surname itself is Lordship, he belongs to ST category.
But then why did you make it general out here?
No, Lordship, that is the farm cannot be categorized as a ST. The person concerned down below authorized signature, Ranjit Kumar Rafa, Lordship, down below.
And let us see some other examples of the registration being SC or ST. This is GN.
Lordship. In the others, my lord, that all are, my lord, that individually they have been filed, my lord, that tender paper. Only, my lord, my lord, tender was the farm, my lord, submitted the tender paper as a farm lordship,
As a
not as
firm.
an individual lordship.
Acha, as a firm.
Lordship. My lord, as
Firm
per,
cannot be scheduled tribe or
Lord,
scheduled caste.
But it will relate to the person concerned who is
It
representing.
should relate. But then you have registered it as
No,
GN.
but that is
Then-
that is the category given by the registering authority. Lordship. The registering authority cannot categorize a farm as a ST or SC. It will be related to the person concerned who is representing the farm. Lordship. It's the sole proprietor. We have stated in all. Lordship. In the petition also we have mentioned he is the sole proprietor.
But now at the end of the day, all the contracts have been given. Now what do you expect? What do you want? That they do the work and you should be given the profit.
Then, no, no, Lordship. The petitioner farm may be given liberty to seek compensation. Lordship.
That is always there. That is always there for you to do. No, but then where's the question of compensation? As per the judgments of the apex court,
Or Lordship may examine the records from the respondent authority, whether this caste certificate was produced at the time, but so far my instruction here is produced. We have stated in our petition.
you bring the records, let us see the records. Have you got the records with you?
reports, my lord, I have to say, my lord, it might be,
You bring the records. I just want to see his tender document.
Lordship.
How has he submitted? Okay. Okay, heard, mister?
DDoS.
Deed as learned counsel for the petitioner who submits that the petitioner's bid document had been no, who submits that the petitioner's bid document had been disqualified on the ground that the petitioner had only deposited 1% of earnest money. Instead of 2% of earnest money, which was required from a tenderer belonging to the general category. He submits that the petitioner belongs to the scheduled tribe category.
That's
And as such, there was no infirmity with the deposit of 1% of the earnest money, as was required under term and condition number 3.1
That's
pertaining to the notice inviting tender, NIT dated 29/01/2022. Mr. J. Handik, on the other hand, submits that the bid document had been submitted in the name of
RBR Enterprise.
RBR
RBR.
Enterprise, which of which the petitioner is the sole proprietor.
Lordship.
As the registration of RBR Enterprise is registered as a general category firm. No, is registered as a firm Is as a general category firm, comma. The petitioner was required to have paid 2% of the earnest money and not 1%. Mr. J. Handik shall produce the records on the next date to verify whether the bid document of the petitioner had been submitted in the name of the firm or in his individual capacity. Yes,
I am appealing for exponent number 10, 12, 13, 14, and 15, my lord. Since, my lord, we have already executed the work, completion certificate we have annexed in our affidavit, my lord. At least, lordship, by seeking an observation, my lord, that our payment may be released, and this pendency of evidence shall not be.
okay,
barred
right,
for
right,
the-
right. Mr.
R.S. Mishra,
R.S. Mishra appears for the
respondent number
respondent numbers
10, 12, 13, 14, and 15, my lord.
10, 12, 13, 14, 15. Full stop. The councils, the Mr. J. Handik and Mr. R.B. Mishra also submit that the contract works in question have been completed by the respondents number 10, 12,
13, 14, and 15.
10, 12, 13, 14, 15. Full stop.
And my lord, that respondent number 11, he has been paid already.
Full stop. Further, respondent number 11 has already been paid his contractual bills. Full stop. List the matter on when can you bring the record?
Thank you, lord.
Huh?
Lordship.
When? You tell me when.
On 4th,
Too many matters were fixed.
lordship.
Ten.
10.
10. Huh?
Lordship.
10. Um. Or 11th. 11? 11. Huh? 11. 12 on 12.
12 with the last day, my lord, it will
Last day.
cover.
Okay.
Only with
On
the
10.
11.
11 on 11. On considering the fact that the contract works have been completed as has been submitted by the council for the respondent.
Madam, I have annexed the certificate, my lord. Page 68 in my affidavit, I have annexed certificate of completion, my lord. Page 68, annexure B, my lord, of my affidavit, my lord, filed on 2023.
And on perusal of the work done completion certificate, work done / completion certificate annexed to the affidavit, the position filed by the respondents number 10, 12, 13, 14, and 15, comma. This court is of the view that there should be no bar. There's a court of the view that there will be no bar for the state respondents in paying the bills of the contract works for which work done / completion certificates have been issued.
Lordship, subsequently, if Lordship finds that there is an error in the.
How does it matter? Even if there is an error, what
Lordship.
we have not done. We cannot say that they have done the work, you should have the
No,
profit.
I'm not
Now,
seeking
how
that,
can
Lordship.
you can file a claim for damages against the authority, not against the private person. He's done his work.
But Lordship will examine the record. Lordship may keep it part heard. Lordship.
No, leave it as it is. No part of it. Yes,
And the 2015 contempt matter, my lord.
what is to be done?
My lord, in this case, not as counsel for the respondent contemner, but as additional advocate of this court was pleased to ask me to obtain certain instruction my lord, with regard to the case of the petitioner. Accordingly, on 30th of November, my lord, I got a written instruction on this matter. And at the same time, this honorable court was also pleased to direct the petitioner for impleading the present incumbent. That is also there in the order. Whether notice have been issued or not, I don't know. But as sought for, only this part I have done. My
Six, three, six, three, six.
two petitioners. 4 works.
That's item one. So outstanding amount is 58,000.
No, my lord. They had wanted to pay it, my lord.
Huh?
Lump sum amount, my lord.
Acha, wait. They're different, okay. So total,
In
Hmm.
fact, earlier, certain amount was in
its amount, it comes to around, 1.39, 1.4 lakh.
Out of my lord, total amount, my lord, 6,27,000. Total amount, my lord,
Total amount payable is 6 lakh.
6,27,249, my lord. And they are, my lord, trying to pay, my lord, 1,42,302, my lord. Since 2016, my lord, they have not developed, my lord. They are still on that amount. They are saying that the remaining amount will be paid in the future, my lord.
Look, I'm having, we'll do this on some other date.
My lord.
Okay, you get a copy, give him
No,
a
my lord,
copy.
there are the subsequent orders was passed, my lord.
only
There is
thing, my
earlier,
lord,
Huh?
I like to make it clear, my lord, I am not representing the respondent, my lord.
Okay.
Here is a contempt case, my lord.
Okay,
Only as sought for by this
Okay.
honorable court, my lord. My lord, you can file photocopy.
so what to do now?
My lord, let me take another.
In fact, my lord, he should have taken step
Some other table.
on the respondent, my lord. One respondent was directed to be implemented.
You are not
But he has not
implemented,
taken
I
step
had
on that.
implemented the executive engineer.
right, on the prayer of the petitions council, list the matter. After the Bihu vacation.
Apply.
Item 5, my lord.
Huh? Will after lunch?
Some difficulty at 2, my lord.
Item 5, what?
Yes.
Yes,
Before hearing, lord, I have some matters fixed at 2 and.
okay. So what do you want out here?
So can it be taken after 2 weeks, my lord?
Okay, right. On the prayer of Mr. R. Dubey, learned counsel for the petitioner who submits that he has got some matter fixed in court number,
Court number 7, man.
court number
Six.
6. This matter after the Bihu vacation.
We have to submit the original to the deputy commissioner within 15th of February. After that, he takes a call with the 15th of March, yes or no. No call taken 29th, we again submit a representation. Saying that kindly take a call on that. That's at page 14. The translated copy though. This is the case. Tomorrow, my entire license would go. And they have issued a document saying that I have no dues earlier at page 16.
Take a Mr. Goswami, he wants a decision to be made whether you're going to allow renewal or not. That's all.
That's all. But if I cross 31st, by virtue of rule 130, my license ceases. That much protection Lordship gives me.
But if there is no any outstanding.
No, there is no outstanding.
No.
Page 16, no outstanding.
Whatever, what, you take a decision either this way or that
That
way.
way.
But don't leave it hanging. That's his case.
Lord,
You see, whether he's got outstanding or not,
No, there is no outstanding. Page 16. They have issued a certificate, my lord.
okay,
Page 16.
right.
Just page 16.
Mr. S. Banik, learned counsel for the petitioner submits that the petitioner has been operating an IMFL bonded wholesale warehouse since 18/10/2016 in the name and style of MS Deepshikha IMFL wholesale warehouse. And the same is located at Hala Wating Bazaar, Post Office, Madhab Nagar, Sivsagar District, Assam. The license number of the petitioner's warehouse is in the register is 102. The petitioner's counsel submits that the petitioner's license is going to expire on 31/3/2023. And as such, the petitioner had deposited the renewal fee,
No, we have not deposited renewal fee. We have-
renewal, no, you have
have-
said out here. in your-
Yes. petitioner deposed, that's the earlier period, you know, the earlier period. There is no outstanding at page 16
Okay.
they have given.
What have I said?
The petitioner's counsel submits that.
Submits that though the petitioner has applied for renewal of his license, comma, the respondent number
Three,
he has not taken a decision. Has not taken any decision on the prayer of the petitioner for renewal of his
four, to be four, I'm sorry.
Four.
Four.
renewal of his license. First up. The petitioner's counsel submits that till a decision is taken by the respondent number 4
And communicated.
with regard to renewal of his license and communicated the decision taken, comma, the petitioner should be allowed to operate his IMFL bonded wholesale warehouse.
That's all.
Next one. Yes, so we'll dispose it of.
Well, if he has any outstanding lordship, then.
Page 16, page 16 for a moment, page 16. The superintendent of excise has issued it, you know. There is no outstanding for the year 22-23, the last year.
If he has outstanding, you close it down. What is there?
Okay.
You take a decision either this way or that way. Mr. N. Goswami, no, Mr. N. Goswami submits that he has got no objection to the prayer made by the petitioner's counsel. In view of the consent of the parties, this writ petition is disposed of with a direction to the respondent number 4 to take a decision on the petitioner's application
For renewal of license.
for renewal of his license and communicate the same thereof to the petitioner. Communicate the same to the petitioner. Full stop. Till a decision is taken and communicated to the petitioner by the respondent number 4, the petitioner should be allowed to operate his IMFL bonded wholesale warehouse. Full stop. The petitioner is directed to submit a certified copy of this order to the respondent number 4 within a period of 1 week from
1 week.
today. 1 week from today.
Obliged.
The writ petitions accordingly disposed of.
Calculation is going on. It will take some more time to calculation is going on some more time. Lordship will fix it at 10 AM tomorrow, 10:30 tomorrow, madam. Because it will.
Calculation.
Calculation is going on.
You
madam.
give him notice.
No, that will be given, madam. That the calculation is going on, madam. Because there are three.
He had already calculated, my lord, class was clean. my
In the
lord.
meantime, you deseal the godown.
The moment, the calculation is moment the amount is given with desealing, we are ready. madam.
Now, are you willing to give the penalty?
My lord, if they specify it, if my lord, whether I can challenge or not, I can only say, my lord, after I receive it. Or subject to that liberty being granted to challenge it will be because my lord, we want to vacate by 31st. Right?
Otherwise,
31st we are vacating because my lord landlord has asked me to vacate. Therefore, without paying the penalty, we cannot vacate. So if the my lord amount of penalty, we may, my lord, deposit in with my lord liberty to challenge it. My lord.
correct.
Without that prejudice to that right.
So what do we do? We'll wait it for tomorrow or what?
I think my lord, listing tomorrow will be better, perhaps then your lordship will see the order and. There may not be any occasion to challenge them also, my lord. We may not.
No, the challenge, so you'll have all the right to challenge. That is
But
not.
without my lord complying that, we cannot vacate the house. And after 31st, my lord, the landlord may initiate the proceeding against me. Because he has, my lord, the lease expires. That
Lease expires on 31st.
But we will pick it tomorrow at 10:30.
Okay, right. On the prayer, the parties list the matter tomorrow.
on his prayer. Man.
On the prayer of Mr. S. Bora, list the matter tomorrow.
Let it be first item tomorrow, my lord. Otherwise,
Tomorrow.
can it be first item
Huh?
tomorrow, my lord? It will take only 2
You mentioned. Because now you see, the list has already been made.
True.
You mentioned it.
My lord, I am facing a today peculiar situation. Your lordship will help me, my lord, kindly.
Item,
The 14. I think lordship in the past lordship took this matter. No, she told me at 1 o'clock, this is a matter. If I can help her, my lord. I said, I don't know anything about the fact, my lord. If I. Proprietary, that is, or lordship can help me, my lord. Peculiar situation. I don't know the fact, and she requested me to. Any day lordships can. Although these are hectic days. At least I just want to go to the fact class. That's
when do you want?
tomorrow possible, my lord.
Tomorrow, now we have fixed too many matters.
Too many matters.
Too many matters.
Then Monday.
Monday? Monday?
My lord, only one thing she's saying that imperial order will take effect tomorrow, she's saying, but the till Monday there is. It is not like- If I learn it, friend.
Okay, tomorrow we'll try.
My
We'll be ready tomorrow then.
We were only required to place an order which.
Yes, actually, you see what she has said. You
My
see,
lord.
there is the case is like this. As per the catering policy of 2010, the licenses that were issued for running these catering stalls was for 5 years. And it could be renewed after every 3 years.
My lord.
Now she has been running the stall for, petition has been running the stalls for 8 years already.
Pretty long time.
Now, the petitioner wants to renew the license. Now, so the petitioner relied upon the provision in the catering policy of 2010, wherein it can be renewed. And also relied upon judgments of the apex court orders passed in the year 2016 with regard to the catering policy of 2010.
Right.
Now, subsequent to this, there has been a catering policy of 2017, which has done away with the concept of renewal of license.
My lord.
So no more license can be given. Only one thing is there, is that if the selection process or anything had been undertaken as per the 2010 policy and letter of approval had been given, so those will continue.
My lord.
But of course, it will be as per the policy of the 2017
17 policy, latest.
policy, where there's no renewal. So now, Ms. Arkeli Chaudhary has relied upon a judgment of this court, wherein it has been stated therein that 2017 policy does not provide for renewal.
My lord.
Now, your
Learned friend.
yes, the petitioner's counsel has said that she will produce a division bench judgment.
My lord.
So now we are waiting for the division bench judgment.
I'll go through it, but I understood my point.
You give me a copy also, let me go through it also.
Yes, yes.
In the meantime, we'll list it tomorrow.
Be clear. Copy.
WA 54/2023. You know about it. Chief Justice and her.
Lordship will see the code.
Huh?
Lordship will see the code. Order passed in another case has been quoted there.
Ha.
Lordship will see. Lordship will find that the earlier division bench has not interfered with the policy of 2017. However, it has clarified, it's like a clarification that those who are there, if they are paying the license fee, then till date, they will be constituted to be legally occupied since they are paid. But henceforth, the decision will be taken by the railways.
So anyway, right, on the prayer of the parties, this is the matter tomorrow. On the prayer of the petitioner's counsel, this is the matter tomorrow.
Right. God bless. I'm so deeply obliged, my lord. First time this situation I faced.
No problem.
My senior advocate, lordship, this situation will come, lordship. And I can assure the lordship, my lord, I will take him to canteen, my lord.
Yes, what to do?
May be fixed on the first week of May.
Why?
Engaged council is having an ear surgery this month,
Okay.
so the date may be fixed. on the first week of
Right.
May.
Adjournment prayer has been made on behalf of the
Petition
petitioners. Has the engaged council
is having an ear surgery.
is having a ear surgery. List the matter in the month of May.
A date may be fixed, Your Lordship.
Why? Okay, give a date. May.
Obliged.
So we are finished for the day.